My name is Fabian Kratzemeyer. I'm a senior research fellow at the Max Planck Institute for Tax Law and Public Finance, and I highly appreciate this opportunity provided by the YANIL board to present my most recent work on European insolvency law that deals with the interplay and the coordination deficits between prepaid proceedings and the EAR. Let's look at the proposal for a prepeg. Its objective is to efficiently realize firm value through going concern sales. There's two phases: preparation phase and liquidation phase. Preparation phase, the debtor looks for potential buyers and collects offers. In the liquidation phase, it is all about getting the deal through to conclude the business transaction and having it ultimately sanctioned by the court. The players are the debtor position that runs the business. We have a passive monitor in preparation phase, which will be appointed as trustee in the liquidation phase later on. And we also have the court that is involved. The European insolvency regulation is applicable only to those procedures listed in Annex A, which is amended from time to time. We also have rules on international jurisdiction with the COMI principle and Article 6 on derivative actions. And then we have a whole body of private international law rules stating mainly that the proceeding shall be governed by the law of the member state in which the proceeding has been opened, with several exceptions, though, especially for security interests, real estate, and labor contracts. Let's look at the interplay of those two acts. The Commission has stated that this proposal shall be fully coherent with other EU pieces of legislation, especially the EAR. But as I will show in the next minute or so, there is still a lot of areas where this is not necessarily the case. Let's start with the application and the scope of the EAR. There is a specific rule in Article 20 of the draft stating that the EAR shall be applicable to the liquidation phase. Liquidation phase is deemed to be listed in the Annex A, but it will not be listed in the Annex A. So this this already compromises the closed catalog approach in the first place. Turning to the preparation phase, it is not even clear whether it will be covered by the EAR, even though, as we have seen, the court is already involved in that early stage of the proceeding. Therefore, we need rules on international jurisdiction. It would be very favorable to have the same rule of international jurisdiction applying both to the preparation phase and the liquidation phase. Another rule on international jurisdiction is Article 22. So it is not all clear how this interacts with Article 6 of the EAR, whether it is further reaching or more limited. And also, to my understanding, Article 22 has some local or territorial jurisdiction aspects to it. At the centerpiece of my publication, there is the applicable law question surrounding Article 27 sub 3, which provides that the transfer and the termination of contracts shall be governed by the law of the member state in which the prepeg has been opened. So it is very unclear why we need a specific rule, a simplified rule compared to the set of private national rules we have in Article 7 and subsequent of the EAR. And lastly, there is also an issue surrounding Article 5 of the EAR, the remedy against international jurisdiction, because under the Commission's view, this procedure should move very, very fast in order to prevent market distortion. But a fast-moving procedure is hard to square with a remedy that takes time. You want to consider as a creditor whether you even raise the challenge. So that is also something to think about. My conclusion is that there is still a lot of work to be done in order to align those two acts, the draft and the EAR, and to set the ground for further harmonization and, on the long run, for a coherent body of European insolvency law. The publication in German can be found here. If you want an English translation, please email. I'm happy to share. And so I can only thank for your attention and the YANIL board, obviously, for this opportunity to present my work. Thank you.